host, the distinguished New York lawyer, author, and lecturer, Alan Schnurman. Each week, Lawline will bring to you the most knowledgeable experts in the field of law today. And now we introduce today's guest and our host, Alan Schnurman.
Welcome to Lawline. There's been a great deal of criticism about the attorneys who have gone to Bhopal, India, to retain victims of the Union Carbide catastrophe. Today we'll examine that issue with Bert Blitz, a partner in the firm of Glazer, Shandell & Blitz. Bert is Vice President of the New York State Trial Lawyers Association. We also have Bob Sullivan, a partner in the firm of Lipsig, Sullivan & Lepakis. Both firms specialize in negligence litigation. Welcome, gentlemen.
Thank you, Alan.
Bert, recently you sent in an article to the New York Law Journal where a member of your firm went to India, and you discussed the conduct of the attorneys on the scene, the conduct vis-a-vis their potential clients. Can you discuss that with us now?
Actually, the genesis of the article, Alan, was as a result of the trip that Ben Bergman, one of my senior associates, after returning from Bhopal, approximately the end of December of last year, was quite disturbed, and I brought him into my office. I asked him why he was disturbed, and he then related to me a series of things that he observed while he was in Bhopal for 3 days. Some of them, some of the items he discussed, involved attorneys who were there, who were performing acts which he was not happy about. As a result of that, we decided to sit down and write an article for the Law Journal in the hope that this problem, the problem of ethics in our profession, can be brought into focus properly. Some of the things that he observed, in particular, were attorneys who were either paying rupees to these poor, tragic Indians in return for retainers, contingency retainers. You understand that our practice is based on a contingency retainer.
Contingency meaning that if when they get money, the attorney will be paid. Is that correct?
Correct. There's no payment until there is a recovery, and then there's a percentage of the recovery that the attorney is entitled to. He also observed pre-printed retainers, where right on the retainer was the right of the attorney to settle the case without the prior consent or approval of the victim. What made it even more horrific to our way of thinking was the fact that these people were not only in the throes of a horrible tragedy, one of the great catastrophes of our time, but they are also, by and large, not educated. Indeed, many of the retainers were not retainers by signature, but rather thumbprint or fingerprint. It then also occurred to us that these people who were largely transitory, they had in fact lost, many of them had lost their abodes, their place to live, would never be reached again, perhaps. We thought that these problems ought to be focused on from within our profession, rather than to bury our head like an ostrich, deal with the problem, and thus the article was written.
Bert, I read your article with much interest, and then again I read Bob Sullivan's reply letter to your article. Bob also was in India. Bob, what did you see?
In India, first I saw an awful lot of tragedy. More tragedy, I think, than the American public really realized, because unfortunately the tragedy became overshadowed by the criticism of the lawyers. There seemed to be more press on the criticism of the lawyers than there was on the tragedy. But speaking legally, I saw perhaps 10 American lawyers, or law firms, some had 2 and 3 lawyers there, of which my firm was one. And while I recognize that it's a minority viewpoint, I happen to be very proud that we were there. I watched the 10 firms work under terribly trying conditions. Conditions that none of us had been in before, that no lawyers had ever been in before. And we were trying to do the best we can We could, but we were overcome with bad publicity. And perhaps a few not nice remarks by certain lawyers that gave the American public the viewpoint that we were all there on an ambulance chase.
Bob, you started off saying that what you saw you never seen before. What did you see? I'm sure the viewers would be much interested. This is a first-hand opinion.
Bert says that the people were uneducated. Very much so. I interviewed people who we now represent who explained to me that they didn't know it was Union Carbide. They thought it was the end of the world. They thought it was a nuclear bomb. People were running, but in different directions. As it turned out, the people who were running were the people who died. The people who walked lived. And the reason is that when one runs, one breathes heavy and inhales the gas faster. And those people were overcome and died. Whereas one man told me he realized that people who were running were dying, so he made his family walk. That man, though, before that happened, he was running with his wife and 4 children. His 10-year-old son fell. He leaned down on the ground. He listened. He realized he was dead. And in tears, he explained to me that he couldn't stop. He couldn't stay. He had his 3 children and he had his wife. And they continued to try to get away, and then he realized they should walk. And he never saw his son's body again. All those bodies were swept away. Tremendous tragedy. 8-year-olds walking around with no parents, looking for an older brother who might be alive. Much more tragedy than the American public has understood.
Indeed, following up with what Robert said, I know that much of the public has read the statistics or the alleged statistics about the number of people, for example, who died in Bhopal. Yet, from what we have learned, apparently the number of deaths are far greater than the 2,000 to 3,000 which are reported in the newspapers. We also know that there's no doubt in my mind, and I don't believe there's any doubt in any attorney's mind who does the kind of work that we do, that we, when I say we, I mean generically, lawyers like the Lipsick firm, lawyers like my firm, lawyers like us, are really the only people qualified, perhaps in the entire world, to be able to do what is proper ultimately to get to the bottom of the truth concerning the Union Carbide faults involved in the lethal gas leakage, and hope that in the final analysis there will be justice in the sense that these poor people will be recompensed properly and adequately and fairly for the terrible damage they suffered from. I believe that the real issue is not whether we as American tort lawyers ought to be in a position to institute the appropriate actions against Union Carbide Corporation, essentially an American corporation, but rather whether or not our profession, in the manner in which it was handling the Bhopal situation, lost in some respect track of what was proper. In the attempt to do the right thing, perhaps the means, and I don't by any stretch of the imagination think it was everybody. It wasn't. There were an unfortunate minority of attorneys who, in their quest for the greed to get the retainers, simply did the wrong thing. And that was the article that was written by my law firm, and the response by Mr. Sullivan was a response that, in large measure, I do not disagree with, because I do think that it's us who has to do this job in the final analysis.
Bob, if a similar situation happened in another country today, what would be your recommendations on how the bar would confront that situation? Would it be similar, or would you, if you had the choice, how would you organize to protect the claims of the injured people?
It should be through the government. The government of India has retained a law firm from Minnesota to represent its interests. The way it should be done is that the government should meet with a number of law firms, perhaps retain 3, 5, no magic number, and have those firms represent the people in a class action responsibly. You see, you have so many victims. Here you have 100,000 victims. How do you analyze each person's injury and what it's worth, and then divide it up? And the only way you can do that is by government-organized systems. You'd have to hire perhaps 5, maybe 10 doctors to open a clinic. Give the people a year, anyone who wants to make a claim, to report to that clinic. Have those doctors examine the people, write a report on what they feel the injury is. Give the responsible party, in this case Union Carbide, an opportunity to have their doctors there to examine also, to verify the injuries. And eventually, once that job is done, sit down and first perhaps try liability with the 3 firms against the defendant, and if the people were successful, then have a commission work with a court such as Judge Keenan and the lawyers and the government and divide the funds.
And of course, by liability, you mean responsibility.
Absolutely.
Who's responsible for this terrible catastrophe?
Absolutely.
By the way,
Bert, let me just ask you this. Now, as Bob has indicated, the government of India has secured one particular law firm. Now, these 5 or 6 or 10 lawyers who were in India and who have obtained retainers, what's the status of those retainers?
those retainers are still valid. The government of India has its own rights in this matter. My understanding of the situation is that the government of India is bringing an action on its own behalf for the damages it suffered and will suffer, mostly financial damage in restoring Bhopal, or attempting to restore Bhopal. In addition to that, the Indian government, from my understanding of what occurred, has also arranged to have many people who have been injured or the estates of dead signed on retainers so that the Indian government represents them. And the Minnesota firm that Robert speaks of is now the firm responsible for that action. Yet, I also understand that all of the people who signed retainers with individual attorneys who went there for the purpose of having retainers signed, have been joined together in one lawsuit. It has been transferred to New York, to the Southern District, where Judge John Keenan is the presiding judge. And ultimately, what will happen procedurally is that a motion will be made by Union Carbide, which will seek a dismissal of the case in this country on the grounds known as forum nonconvenience.
Meaning?
Meaning that Union Carbide will say, since all the witnesses, since the occurrence took place there, since Union Carbide's Indian Corporation is in Bhopal, that's where the case has to be tried.
The case should be tried in India and not in New York City.
Yeah, that's going to be what we all anticipate to be their strategy.
Is there any indication on how many retainers have been signed up by American lawyers?
50,000 would be. I've been
By
to
10 law firms? 50?
Oh, no,
No, there are many more.
There were 10 law firms. You see, we were there approximately a week to 10 days after the accident. But there was a couple before us and many more after us, and many people were, they retained Indian attorneys who referred the cases to the United States. There is a steering committee of 28 law firms who represent these individual plaintiffs, and I would say there are another 30 law firms involved. There are approximately 50 to 60 law firms involved representing individual claimants.
There's even more than that, Alan. I can give you an example of what happened in my law firm only last week. We received a phone call from a fellow out in California.
An attorney?
No. He represented himself to be an investigator. He said over the telephone that he had somewhere between 1,000 and 2,000 of these cases with retainers from people who had injured in Bhopal and wanted to know whether my law firm would be interested to become involved with these cases. Indeed, he suggested that if we paid him the sum of $135 per case, which represents his, quote, investigative fee, end quote, all we need do is go to California, where there's a stock house in San Francisco, and pick up as many of these cases we want at the rate of $135 per case. When I made the following inquiries, his responses were quite interesting. When I said, Mr. X, I said, when I go to California, will I have the right to evaluate each case on its own merit? He said, no. We give you a package, 500 cases. I said, well, what kind of retainer do you have? He says, we have some thumbprints and we have some signatures. And I said, look, I'm not interested. I can't conceive that a reputable law firm could be interested in this kind of situation. So what I'm suggesting is that perhaps these poor people who are being offered 50 rupees per case, which is the equivalent, I think, of some $3 or $4, signed as many retainers and gave as many thumbprints as they can get rupees in return, which I don't doubt for a moment would be our response too if we were like them. You see, Alan?
Well, how do you feel about something like that? I don't know if this gentleman called your firm.
No, I didn't hear from him, but we did receive similar offers. Those were the circumstances that were so difficult. You see, the personal injury lawyers who were there trying to work ethically and professionally had to put up with things like this that were going on. The first thing we did before we went over there was to debate whether or not we wanted to risk being called ambulance chasers. We are not ambulance chasers. We went there because we felt we had a duty. We were asked to go there by a very prominent Indian law firm that represents large companies in Bhopal. And the employers at the companies had gone to their attorneys and said, what should we do? They contacted us as a personal injury law firm in New York, and we went there. But the first question was, do we want to be associated with the other with the other lawyers who were being called ambulance chasers? And there's no doubt that there will be people who will say we were over there ambulance chasing. So we went. There's only one way, as I see it, to sign up these cases. You point out, Bert, that how do you find these people? They don't live in homes. They don't have addresses. They live in huts. They live in tents. Some of them were beggars who had no legs, who sat on the street, and during the day they beg. And at night, because the weather's warm, they just lay down and go to sleep. And the next morning they sit up again. How do you contact these people? And the way we did it was we only took cases through employers. In other words, if a man had a factory or a company and he employed 200 people, we would go to him. He was educated, and we would say to him, number one, we don't want the bogus claims. We only want people who are genuinely hurt. We don't want to represent people who say they have a $50 case, a $200 case. Nonsense. And second of all, we only want to retain people who we'll be able to find through you. You see, we have the plaintiff, but we also have the employer, because people don't change jobs there. Once you get one, you hold on to it forever. They're hard to come
Bob,
by.
can I ask you how many cases your firm has?
1,000. And there's a reason we have exactly that many.
What's the reason?
We wouldn't take more. There are firms who take 10,000, 25,000. That's their business. I found for our firm it would have been irresponsible to take more. I don't see how, and we're a large personal injury firm. I don't know of many that are larger, but I don't know how one manages more than that.
I cannot imagine taking 1,000 cases into any office, no matter, even if you have 50 lawyers, without it just turning the entire office upside down.
May I make an inquiry of Mr. Sullivan? Of course, 1,000 cases involving one accident is quite different than 1,000 cases involving 1,000 different accidents. This we appreciate. Yet it still seems to me that it will be a difficult in the respect that logistically and from a practical standpoint, the separate evaluation of each individual becomes very important. There's a humanistic,
Absolutely.
sensitive aspect to what we do for a living, because we're representing, in all instances, victims. It was for this reason, by the way, that when I was offered a package of 500 cases or a package of 1,000 cases, that I could not conceive of mass producing something that to me is a very personal kind of situation. When I take in a case in my office, it's done, and I know it's done in the Lipsick firm the same way, with a great deal of concern, with a great deal of sensitivity. We may spend 4 or 5 hours with one client going through factual data, especially if it's a complicated medical malpractice or product liability case. There is a problem, and you bring the problem to its fore when you say, how can you bring on 1,000 cases? There is a problem.
But the answer to it is this. I agree with you that we cannot do that here. So should no one represent these people because Union Carbide injured so many?
Bob, let me ask you this. You know, there's a whole movement now in the United States, anti-trial bar.
Right.
And they seize upon this event. Right. They seize upon, in your own words, this ambulance chasing. Right. And they say, look at this. Look at the money that the trial bar is earning. And as Bert brought out, it's a contingency. In many cases, it's a third.
Yes.
So, in fact, there was a recent article that indicated on the asbestosis cases that the trial bar got 60% of every dollar. So how do you answer this massive media campaign against the trial bar?
You're not going to overcome the media campaign. It's insurance companies. They have too much money. That media campaign will continue forever. Who else will do the job? Who else will represent these people? Who will go over and invest so much money and so much time with the chance, perhaps, that the cases will all be booted back to India and that the American lawyers will make nothing? We'll take the gamble. Perhaps we won't get paid. We'll do a terrific job. In the end, we will get paid, but not a third. That will never happen.
Bert, I'm only giving the Bhopal incident as an example of one thing that media is going to show what the trial bar is doing. How do you answer that? Here's your forum. What can you say to the viewers who are listening? What service is the trial bar doing? That's what I want to know.
We have had a very difficult time of it. I have spent a good part of the last 5 years defending what I do for a living. Yet I know within myself how hard and how diligent not only my firm works at its cases, but all of the other reputable law firms work at their cases. I know, as we all know, because we have become involved with the courts and the court system and the contingency fee system, that there is no other way for a person, other than a very wealthy person, to get fair, proper, adequate common law recompense, something that has been ingrained into my mind from the very first day I went to law school and has been ingrained in every other attorney's mind as well, other than the contingency fee. A poor person couldn't possibly begin to afford the services that we render. An average medical malpractice case may involve several thousand hours of work. The trial may take 9 weeks. The testimony by physician experts may exceed $15,000, $20,000, $30,000. Where is a poor person who has had his or her wrong leg removed or died unnecessarily, leaving young children with no recompense, ever going to receive the kind of justice that this country properly affords but for the contingency fee? It's unfortunate that profit motive, Bob mentioned insurance companies. I'll extend that to, quite frankly, the medical profession, who seeks immunity, who seeks special privileges under the law. I'll extend that to the product manufacturers who manufacture products that maim and damage human beings. They seek special immunities. Recently, the entire airline business, when airplanes crash, and we all know what happens when an airplane crashes, almost in every instance, everybody perishes. They sought special privileges through the federal government. Fortunately, we were, through a great deal of work, lobbying work, we were able to defeat that. I'm tired of defending my profession. I think we do a wonderful job, and the proof is in the final analysis. When the very doctor or the very product manufacturer has a problem that comes close to his home, he's the first person that's going to come to one of us, Mr. Sullivan or me.
Let me add to that. Where were the doctors? You know, people criticize us. We went there to try to help those people. Do you think those people could afford to pay? Perhaps we earn $200 an hour. Someone may laugh at that. Do you think these people could have afforded to pay $10 an hour for us to work on it? We have to work on a contingency fee. But where were the doctors? 4 doctors went over for Union Carbide to try to explain what the long-range effects would be. 100,000 people were injured. Were the American doctors over there helping treat people? They didn't go. What has Union Carbide done? They've gone around and said, we'd like to settle this case, we'd like to settle this case. What about the orphanages? What about the hospitals? Have Union Carbide staffed them in any way, shape, or form? They've done nothing but walk around and say, well, this case should be settled. And talk about what a safe company they are. Imagine the gall of it. Find another company that's killed 5,000 people in 2 hours, as they did, and still walks around and talks about what a safe company they are. And yet they criticize us. We were there, we were trying to help. You know, another thing too, we make a good living. We do very well without the fees we're going to make in Bhopal if we ever make a dime. But if we didn't go there, we would be doing a tremendous disservice. If Lilco has the same problem that Union Carbide has, everybody on Long Island is going to be running to a personal injury. First they'll be running away, and then when they get back they'll be running to a personal injury lawyer. Don't those Indian people have the right to the same representation? And we're willing to do it on the risk that we won't get paid for anything.
I might add that the viewers may not understand fully that should the cases be dismissed here in America, to go to India would present a terrible difficulty. To begin with, there is no contingency fee system in India. Secondly, there are immense filing fees which prohibit most of these people from instituting any kind of an action. There's no juries in India.
In summation, if you had to sum up our conversation, Bob, how would you say?
It's very easy and popular to criticize the American personal injury lawyer. Maybe one or two are doing things that we're not proud of, but I tell you, we were there trying to help and to accomplish good things.
Bert?
Well, we've got to clean up our house too. There's no doubt about it. I don't believe that we are perfect. Yet, I'm proud of what I do for a living. I have never spent a moment unproud of what I do for a living, and I congratulate Mr. Sullivan for trying his best as well.
Thank you very much. You were listening to Bert Litz and Bob Sullivan, and this is Alan Schnorman, and thank you for watching Lawline.
You have been listening to Lawline with your host, New York lawyer Alan Schnorman. Mr. Schnorman will be back with you again next week at this same time.